Hi, everyone. Welcome to episode 119 of the Immigration Lawyers Podcast. Thank you for tuning in. It's been a little bit slower coming out with new episodes, primarily because of the lack of sleep over having a toddler, as I'm sure many of you have experienced before, and many of you will. But it's made it kind of hard to just have the energy to do these kind of extracurricular activities. But, there's a lot of fun stuff lined up. Especially this episode, I'm going to be doing a part two, a continuation of the history of immigration, which is fascinating because so many different aspects of issues that we deal with today, we see through the study of the history where they were birthed and what was the mindset that led to the creation, for example, in this discussion here, of how the various inadmissibility statutes came up and how these agencies were created in the first place, how they got their powers. And it's kind of scary how much power they have and what kind of like ruthless stuff would happen. That really was never checked. It's still on the books, and they probably still have the power to do this kind of stuff. So we're going to go over that. But before starting, I wanted to give a reminder for Immigration Lawyers Toolbox premium members, the people that are part of the Masterclass program as well. Masterclass Session 8 or Mastermind Session 8 was released, focused on marketing. It's almost 40 minutes going over all the marketing and branding things I've done and learned in the last month. So it's chock full of information and value there. Also, the typical daily tips on marketing and branding, as well as immigration law tidbits, is coming out every day for members. Just one message for premium members and potential premium members. The existing price will continue for existing members until March 1st, but the price has increased to $50 a month. The program is chock full of information that will really help you take your firm to the next level and really, even double or triple the revenue that you're making, or, negative double and triple the hours you're spending on making that same amount of revenue. And that's the goal I have for all of you. Okay, so without further ado, let's get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqklaw.com. Okay, so we're going to be looking at the history of immigration from 1880 to 1905. So 1880 is post-Civil War era. I think there was a great recession, long depression during that area too. During the Civil War to fund it, they issued a lot of money, greenbacks, paper printed money, and it was super inflationary. And then they have to roll that back. Whenever they do that kind of stuff, which is kind of what they're doing right now too, there's a heavy recession or depression that comes. Going to 1880, in the previous discussion, we ended when the Chinese Exclusion Act was kicking in. But before I wanted to get into that, when I was doing research on this area and on this time, I came upon a map by the National Geographic Society. It's a very interesting map because let me describe how it looks. It has the map of the United States in the middle, and then it has Europe to the right of it and Asia to the left. And it has these arrows coming in also from Canada and South America from the north and south, arrows coming to the U.S. And the map shows the populations that came to the U.S. during the late 1800s, between 1870 and 1900, the largest number of groups coming. Now, almost all the discussion we're going to have today, and was the impetus of a lot of the immigration laws, comes from East Asian migration. So here it says Asian migration was 243,900. Let's say 245,000 just to round it up, from Japan and China primarily. But China really 215,000. So the bulk of it from China. And they went to Angel Island. That's the port they would primarily enter in San Francisco. And then from South America, it was 91,000. Let's round up, say 100,000, which is less. Canada, it was 820,000. So Canada had like almost 4 times as much immigration than East Asia. But when we look at European immigration, total numbers were almost 11 million people. So 3 million from Southern Europe, 7.5, 7.6, 7. Let's just say 7.5, rounding all these, from Northern Europe. So 11 million people from Europe, 215,000 people from Asia, but all the laws and exclusions and everything were based on Asian people. So that just gives you a perspective of where we're going when we see how laws are passed. And one thing that people always talk about, and right now we're election year, And there's a lot of issues with social injustice and all that kind of stuff. And people say we need more laws, we need to do this and that. Laws are usually made to hurt one specific group, give power to one and hurt another group. It's really, that's the way it works. And typically the group that gets focused on when you look at large mob movements, which is democracy, it is, a mob mentality. It's the majority wins. That's mob mentality. The Constitution, the way they made it, they wanted to have a constitutional limitation where they said, okay, these minority rights are protected to a certain extent, and we have sort of safeguards against that. And when we talk about the things that we're talking about right now, we'll see the safeguards failed. But when you see the riling up of a mob mentality passing these rules, a small group, now I don't want to do the math because I want to make a mistake, but whatever percentage 250,000 is of 11 million, look at that and then decide, like, should the laws have been made towards Europeans coming too much if the worry is that these foreigners are coming, or would it be towards Asians, which is a small group that doesn't have representation or looks different, all that kind of stuff. It's a horrible situation. But okay, so there was I can't just say Europeans were fine. There was a lot of anti-immigration and a lot of anti-Catholic sentiment going on. So especially anti-Catholic. Southern European countries are mostly Catholic, and so they felt a lot of this. But when you look at in 1882, the Chinese Exclusion Act, May 6, 1882, it was really the first act that specifically prohibited a certain country and the people from there. So you see, that's the mentality when it comes to anti-immigration society, anti-immigration legislation wasn't towards Mexicans, it wasn't towards Europe, it was really garnered for Chinese people. And this act prohibited all immigration of Chinese laborers, skilled and unskilled, and Chinese employed in mining, from entering the U.S. for 10 years under penalty of imprisonment and deportation. So this was later extended, and we'll talk about that, but originally it was set for a 10-year period. Now, the people who wanted exclusions from this could get this certification from the Chinese government to let them be able to immigrate. And this is primarily people that were maybe diplomats or people that worked, in-house with them, followed them, servants. But those are hard to get to and not always acceptable, and they had their own issues when they would come here, whether they would accept that paperwork. Also, during this time, Congress, in this same act, they started emphasizing that states can't make up their immigration decision, so it's more of a federal thing. And so one thing they did is they refused the right for state and federal courts to grant citizenship to Chinese resident aliens, but although the courts is still important. So the federal bureaucracy, the federal centralized power is centralizing power away from the states in this regards. Now, for those that were Chinese American here, they needed to be re-registered to be allowed back in the U.S. So there was this complicated registration process, which not everyone did, but they would need to do. And those carriers, and you see this now, when someone comes to the United States and doesn't have a valid entry document, and they're expedited or removed, CBP will fine the airline. This is where this started. They say carriers face fines and even imprisonment if they let someone come in from China that didn't have the registration papers being proper. So this is where that started. And then amendments were made in 1884 that clarified the law applies to ethnic Chinese, not just people who are born in China from Chinese descendants, but also people born outside of China from Chinese descendants. So you can't get away from it. You can't have a passport from Japan or a passport from other country. But if they figure out that your ethnicity is Chinese, then you have to register and you're excluded from coming, most likely because you're going to do labor. And so this is kind of harkens back to the situations with unauthorized employment. The reason for this legislation and the basic power of it was towards prohibiting Chinese laborers, so skilled and unskilled labor. So we're seeing employment-based categories, work visas. This is where it comes where that they make they draw the line. It's not, they don't just say Chinese people can't come, but they make it against people who could potentially work, which essentially is everyone. Later on in 1888, so this was 1882, where they had the Chinese Exclusion Act. 84, they expanded it to include all ethnic Chinese, and then 1888 they expanded it, prohibiting re-entry after leaving the U.S., leaving an estimated 20 to 30,000 Chinese outside the U.S. at the time stranded. So there were Chinese people. There wasn't exactly if you're already here during the time and you registered, if you go back, you have to register again to come back in. But they passed this, not saying after a certain date or having some sort of cutoff. It just said this is the rule now. So there were some Chinese people, 20 to 30,000 were outside the U.S., just going to visit family or whatever, and all of a sudden they were stuck outside and they couldn't come back in. So this led to lawsuits. The Supreme Court still held this valid. Like in Che Chang-ping v. United States, 1889, the Supreme Court made the decision that the exclusion of foreigners is incident to the sovereignty belonging to the government. This gave the power essentially to central government to exclude anyone who they wanted or find inadmissible, as we call it days. Now, when I was trying to shepherdize or look at Westlaw and stuff to see if this is still law, I couldn't find any negative treatment. Really, none of the cases I talked about here, I couldn't find that red flag that said they're not valid anymore. So keep that in mind. What was interesting, too, is there are trade policies that the U.S. and international treaties that U.S. had made with other countries where these immigration statutes that they passed would contradict those. And the court said that even though it was a treaty, which a treaty is law of land, if Congress makes a new law and passes it, it overrides that treaty. So that was really interesting to see that they allowed that to happen and subjugated treaties to congressional power. There's a lot of constitutional law being built based on immigration. You see immigration builds so much of all the other characteristics of law. It's so interesting that it gets such a short end of the stick when it comes to respect in the legal field, where immigration has such an expansive effect on criminal law, family law, constitutional law, commerce, international treaties. Everything gets touched upon this. It's fascinating. Also, another decision the court made here, the SCOTUS made, was that it limited the role of the judiciary in immigration matters. So that we're going to go into that more, but it's very interesting to see how it limits that. Now, there's this term we all know about consular nonreviewability. Some scholars say that this is where the idea of consular nonreviewability happened, when the court said that we're not going to look into, we're limiting the role of judiciary in immigration matters. Some say not, but some say that the doctrine came from here, where they stopped reviewing what the immigration matters are and leaving it up to them. Now, the facts of this case, there was a guy named Che Chang-ping who was a Chinese citizen. He moved to San Francisco in 1875. And he was working here. And then in 1887, he left to visit his homeland of China after obtaining a certificate that would entitle him to return to the U.S. The certificate was issued in accordance with the Chinese Exclusion Act. But in 1888, while he was outside the U.S., the Scott Act became law, and that act forbade his reentry. So he was denied passage on coming to the U.S., and you'll see this a lot. There was this one freighter or ship called the Belgic that was from China to the U.S., and the captain there detained the guy on board. And so he filed the applicant for admission filed a habeas corpus claim, saying, I need due process. I'm being held. And the court essentially said, tough luck. But it's interesting to read the wording. This is a quote from the court decision about Chinese people. They say, they, meaning the Chinese people, remain strangers in the land, residing apart by themselves and adhering to the customs and usages of their own country. It seemed impossible for them to assimilate with our people, or to make any change in their habits or modes of living. As they grew in numbers each year, the people of the coast saw, or believed they saw, in the facility of immigration and in the crowded millions of China, where population presses upon the means of subsistence, great danger that at no distant day that portion of our country will be overrun by them. I mean, this is like crazy language. Unless prompt action was taken to restrict their immigration. Now, when you look at the numbers of people coming out of time and how many are in California, you see that we haven't been overrun. There's space and food for everybody. So a lot of times when we scare the hell out of people, and frankly, this comes to even climate change and stuff, when we scare the hell out of people of these projections and stuff like that, and it doesn't come to pass, it shows that's not the way to do it. Scaring people doing something is not good. Let's think about different ways to accommodate everybody so we can all make the most of it. Now, the Chinese Exclusion Act also led to an expansion of the power of U.S. immigration law through influencing Canada as well. So, U.S. had a lot of control. They influenced Canada, and they passed their own Chinese Immigration Act of 1885, which had their own limitations, a head tax on Chinese migrants, and increased pressure even after that, which banned most forms of immigration by Chinese to Canada in 1923. Now, they tried to do this with Canada and interfere in their politics, but they weren't down with that. The Chinese were going to Mexico in large numbers, and Mexico at the time had labor needs that needed filling. So they didn't do that. They didn't create any Exclusion Act. But what happened with the consequence was the U.S. resorted to heavily policing the border with Mexico. So you see there, the fear we have now of, first was Mexicans and Central Americans to come to the U.S. Actually, at the time, it was Chinese coming through the border because they're afraid of the numbers coming. So a lot of the border policy with Mexico is because of Chinese people. And even now, I remember it was a year or two ago, I heard the largest stat of people coming to the United States or visa overstay or something were Chinese nationals. So you see, this Chinese issue led to political disturbances between U.S. and Mexico as well, and also affected the nature of the relationship and the power the U.S. has over Canada. Now, we talked about the Chinese Exclusion Act. This was like the real hardcore first act that excluded a certain population. But during that same year, there was a thing called the Immigration Act of 1882. And this is considered by many to be the first general immigration law because it created the guidelines for exclusion and the creation of inadmissible alien categories. So we used to call it exclusion, now we call it inadmissibility now. And also led to the creation of the first agencies. So the 1882 Act imposed a head tax on non-citizens who came to the U.S. at the American ports. And that money was used to fund the first immigration bureaucracy that would police this stuff. So we started seeing the creation of a centralized immigration service along with port authorities that could police this. Now, the inadmissibility exclusion statutes that were created there focus on certain categories. So they were focused on people who are criminals, lunatics, idiots, and this is what's in the idiots, or any other person unable to take care of himself or herself. So we see the initiation of public charge statutes there. There's also the initiation of the 5-year ban for someone's, expedited removed, as we call it now. And as I said, it created the apparatus for ICE and CBP. These are the precursors were made at the time. All this under the U.S. Treasury. Now, when we talk about public charge at the time, this could have been including a pregnant or a single woman, someone's disabled or sick or poor. These are all people that were worried would come here via public charge, and they wouldn't allow them in. Now, they did create an exception for criminal stuff where they say convicted of political offenses would be okay if there's criminal history. And this kind of is trying to reflect the traditional American belief that the United States is a haven for those persecuted by foreign tyrants, almost an asylum kind of thing. But that would, as you know, go up and down over time. Later in 1885, the initial employment-based restrictions like perm kind of stuff start kicking in under the Alien Contract Labor Law, which made it unlawful to import aliens into the U.S. under contract for the performance of labor services of any kind. And then it was amended to 1887 to make it enforceable by the Secretary of Treasury. So they passed a law, but then they have an enforcement statute. They added that later. This is all still under the Treasury. Then in 1888, there was a separate act that said any immigrant who had landed in violation of the Alien Contract Labor Law could be expelled within 1 year of arrival, and this would be reiterated later in the Immigration Act of 1891. So they're making it really hardcore on people coming here for labor purposes. And yes, always goes back to labor, economics, finance. There's obviously racism involved, but if everyone's getting rich, a lot of times they're not thinking about the people taking their jobs or money. It's when there's this recessionary period. And let me actually go online to see exactly when this recessionary period is to give a more exact description. I studied a lot of finance and economics when I was in law school, so I was tired of studying law school, so I started studying finance and going to the library and get every book they had on economic finance. And I remember reading this period is really tough, the post the Great Depression, because of all the greenbacks. So that's where greenbacks came from. Lincoln prints a lot of money to pay for that war, and there were consequences afterwards. So I'm on a list of recessions on Wikipedia. A recession of 1802, that's too soon. We go later in time. Recession of 1838. Wow, there's a lot of recessions. Let's see, Okay, so there was we're dealing with 1880, so that's where we're starting. So the Civil War happened, I think, 1860s or something like that. There was a recession from 1869 to 1870. Here it says, what was a few years after, a short recession after the Civil War. And then the Panic of 1873. So where were we at right now? The years we're looking at are 1888. So, okay, now, this is called a Long Depression from 1873 to 1879. So this is right before 1879 is when things are getting frustrated. Eventually, 1882, the Chinese Exclusion Act happened. So they just went through the Long Depression, ended in 1879 according to whatever calculations they have. But then here you go, 1882 to 1885 recession. I'm going to go and look into that. But then again, 1887, there's another one. 1890, there's one. Usually there's a recession every 5 or 6 years. But you see, like, this is compounding itself, especially after that Long Depression. So let's look at the 1882 depression. According to National Bureau. So as you see, there's during these periods that there's the political will to push these kind of laws. And what happens is people are frustrated, looking for excuses. The Congress, congressmen just, it's a popularity contest. And so they're doing whatever is going to make voters happy. And Chinese people here couldn't even become citizens, so there's no voting on their part. And so they were not a constituent that made a difference. So and then what happens is you get laws like this that hit you, but you don't get anti-Italian laws or anti-Spanish or anti-German laws, because a lot of those people have naturalized and became citizens, so they wouldn't do something like that. And that's what you see here. So they had the Immigration Act of 1891 I mentioned briefly, and in this act, it was a modification of the 1882 Act, and it focused on immigration rules and enforcement mechanisms for foreigners arriving from countries other than China. So this is an extension of that act and just a wider-ranging immigration act. Now, in 1891, they extended the federal government's power to deport immigrants by adding categories of not only excludable people and admissible people, but also those who are deportable, adding polygamists and those suffering contagious diseases. And even others assisted by others for the payment of passage. Now, they made it a rule where vessels had to collect biographic information and give it to the inspector at the port of entry, so CBP at the time, who had the authority to conduct a medical examination to see who was excludable for health and dangerous disease reasons. And this marked the beginning of the medical exclusion that we now see, where someone who's doing an immigrant visa, for example, needs to do an x-ray and all that kind of stuff potentially, or at least do a checkup for TB, whatever, STDs and all that other stuff. And that's why when we look at the old videos of like Ellis Island, you see where they have a medical board to check, and they have a separate place they hold people for that. And then also new powers and requests for procedures went out to the Secretary of the Treasury, who was running immigration. At the time, there were only a few, I think, secretaries or ministries. So, and they say, make some immigration rules for enforcement, but don't make him too hard on commerce. And then the Section 7 of the Act created the Office of Superintendent of Immigration, a new executive bureaucratic office that would have 3 clerks and a superintendent appointed by the president, who work under jurisdiction of the Secretary of Treasury, and they oversee the immigration apparatus and inspectors throughout the country. So it's still like one lump sum, kind of like DHS before it was INS and that separated. So it's DH under DHS. Now the first challenge to this act came in a case called Nishimuro Ekiu v. United States in 1892. And in this case, a woman was denied entry under the Immigration Act of 1891. I believe it was a Japanese national. And she sued for habeas corpus and challenged the constitutionality of the provisions of the Immigration Act of 1891. And the case was decided against her. Now, in this case, the woman was held because they believed that she didn't have a husband that she said that she had in the U.S., and so she would be coming here to do unauthorized employment potentially, and to maybe be a public charge because she may not have the means to support herself because she's a foreign person with no family or relatives in the U.S. And because of that, they were denying her entry and holding on to her at the time. And the court said the government can do this if they want. Now, one of her arguments said that the proceedings that happened to get the information about her, at the port to see if she had problems did not occur, and their argument was that they didn't occur under testimony under oath. And because there was no record of any testimony or the decision of the inspector at the port, that this is not valid. But the court said that they're allowed to do whatever they want at an inspection examination, and there's no requirement that there be administered oath or they take record. Essentially, the inspector could make any decision that they want and claim it's true, and that's going to be followed. Later, there was a case, Yamataya v. Fisher, this is known as the Japanese immigrant case, that challenged the constitutionality of provisions to exclude and deport immigrants, arguing that the provisions violated the due process clause of the United States Constitution. And this was the first time the court ruled positively, allowing judicial review of only procedural due process claims. So if there are substantive due process claims, they wouldn't care for immigration, but if there are some procedural issues, they will look into it. So some plus from that, but in general, they found the guy to be deportable. And as I mentioned, it was during this time because of that statute where the Ellis Island situation came, where people had to come at certain ports so they could control the entry and review them for medical inadmissibility and other reasons. Then in 1895, there was a restructuring of the immigration bureaucracy. They renamed the Office of Immigration as the Bureau of Immigration and changed the title of Superintendent of Immigration to Commissioner General of Immigration. And then in 1903, later on, we skip ahead, they transferred the Bureau of Immigration from the Treasury Department to the newly created Department of Commerce and Labor. So we see immigration, again, was thought of under the commerce and work and labor aspect of the law, This is one of many different changes that would hop around until where it is today under DHS, and frankly DHS and DOS and somewhat DOL and sometimes Treasury for OFAC. There's a million different places you find it. And they created an immigration fund where it was based on a head tax that would finance this kind of service. That was in the future. We still haven't got to 1903, but I wanted to give you a heads up on what was happening in that direction. So now we are reaching the turn of the century, and we reached the McCreary Act. Now, the McCreary Act was in 1902, and this is where the renewal of the Chinese Exclusion Act came under the McCreary Act in 1902. And interestingly, one key set-up provisions in it shifted the burden of proof or demonstrating the right to be in the U.S. onto the Chinese resident. So this is about to get really messed up, and we're going to talk about right now. But it was up to you to prove that you have a right to be in the U.S. And what you will see is, even if you have documentation of it, doesn't necessarily mean you have the right or they'll care. So the chief enforcement mechanism for this change was a thing called a certificate of residence. And Chinese were already required to possess this certificate of residence that served as proof that they're in the U.S. legally and they could remain here. And the certificate contained their name, age, local residence, occupation, photograph, and they had to keep it with them at all times, kind of like a green card of sorts. Now, if you didn't carry it at all times, you were punishable by deportation or a year of hard labor. This hard labor is crazy for not having a piece of paper on you. Also, Chinese were not allowed to bear witness in court, and they could not receive bail or in habeas corpus proceedings. So no bail. That's so messed up. Another part of the act said that they required 2 white witnesses to testify to a Chinese person's immigration status. It's just crazy. And they're doing everything you could to just put them in a bad spot. Now, despite how harsh this law was, there was huge issues of the practicality of its implementation and enforcement. Now, actually, there were only 13,000 Chinese laborers registered, about 14% of those subject to the law. And the cost of arresting and deporting as many as 8,500 unregistered Chinese people was estimated at more than $7 million, but Congress had only authorized 60,000, and it failed to provide a mechanism for deportation within the McCreary Act. So when we had one case that popped up, a guy named Nai Luk, and he was a Chinese Civil War veteran. So this guy was in the U.S. Civil War, and he was arrested in New York for failing to register, and the judge in New York said that there was no deportation provision in the law, and the guy could not be detained indefinitely, therefore he should be released. So what happened is the government got together and then passed the McCreary Amendment, which provided additional 6 months for Chinese people to register, as well as additional restrictions on certification and stuff. So they tried to make it harsher and add these things that could prevent this from happening, but they weren't really successful in enforcing this at the time. But what happened is in 1895, there was a case called Lem Moon Singh v. U.S., and it upheld the McCreary Act amendments, but it also upheld the idea that there's no habeas corpus relief for foreigners at entry in the United States. So a lot of it is similar right now. If someone's at the port of entry and they're being held on, there's not really anything you can do. But in these extreme cases, I mean, if you have a green card, for example, let's say you're not a visa holder or whatever, but if you have a green card, they're essentially saying is you still don't have a right to get in, and they can make up whatever they want to hold you out. So we move forward a little bit and we go to 1903, and this is where we add some more stuff to the inadmissibility statute. And all this stuff, if you look at INA 212, you're seeing the history of how the admissibility statute was. INA 212 is 1182, USC 1182, I think, but 212. You see how I'm pass here. So the government passed this one that said it added anarchists and political radicals to people that are excludable and deportable. And then there was another anarchist Exclusion Act that was added that had that. But they also added 4 other places. So there's also people with epilepsy, beggars, and importers of prostitutes. It also allowed for the deportation within 2 years of anyone unlawfully in the country and raised the head tax on immigrants. So this anyone unlawful in the country 2 years, we have that now even where the expedited removal statute exists, and they have it where if you're a few days in the U.S. within the border, President Trump's trying to make it 100 miles of a border within 2 years, 3 years. You're seeing that stuff. This is where it came at the turn of the last century. So this was the first legislation in the U.S., and we're looking at the anarchist part of it they added, since the Alien and Sedition Acts of 1798 that called for questioning a potential immigrant's political beliefs and barring anyone who disbelieves in the organization of our government or anything like that. So this stuff, every 100 years, this stuff comes back. You're seeing almost 1800 has happened, 1900 has happened, 2000 is happening. So this is something that's the cycles, and that's the thing about history, it just repeats itself. Now, at this time, we have another Japanese case, and we see more and more of the challenges are coming from Japanese people. They probably had more money to be able to file these things, so you don't really see them from Chinese people anymore. But Yamataya v. Fisher, 1903, this was a case I talked about, the Japanese immigrant case I mentioned earlier. But the one I want to reiterate here is that they say investigation and actions of the executive offices in the deportation process were not subject to judicial review. And so this was a codification of a kangaroo court. It was held that even a hearing that an immigrant cannot understand, the English, was not a violation of their Fifth Amendment due process rights. But the court did argue that if a person was deported without a hearing, Fifth Amendment due process would be violated procedurally, and so provided some ability to go through the courts. And this is still law. I didn't see any negative treatment on this. Then there was the United States v. Ju Toy, interesting name, Ju Toy, 1905. The Supreme Court further allowed Congress to deny the writ of habeas corpus, even to persons claiming to be United States citizen. This is the really messed up one. So in this case, they held that a citizen of Chinese parentage seeking admission to the United States could be excluded by the administrative immigration authorities, even when being denied a hearing before a judicial body on the question of whether they were indeed a U.S. citizen. The court determined that refusing entry at a port does not deny due process, and held that findings by immigration officers are conclusive and not subject to judicial review unless there's evidence of bias or negligence. This case marked a shift in the court in respect to habeas corpus petitions and altered the judicial landscape for citizens applying for admission to the United States, as well as for those facing deportations. Again, I didn't find negative treatment on this, and so they're saying a U.S. citizen goes out there and the port authority doesn't believe him, then they're stuck. So that's messed up. Here, Ju Toy was a Chinese man who was born in the United States, natural-born citizen, and was not subject to the 1882 China's Exclusion Act or the Scott Act or all the stuff that happened afterwards. He had visited China, and he was coming back on the Doric, and on his return was denied permission to land and was ordered to be deported by immigration officials, even though he was not an immigrant. So he sued on a writ of habeas corpus from a federal district court, and they ruled that Ju Toy was a person native to the United States and ordered released, and that was appealed by the government to the Supreme Court, which said no. So we have Justice Holmes, which is a famous justice, which gets a lot of respect, delivered the majority opinion in 1905, and held that a petition for habeas corpus should have been denied because it alleged nothing except citizenship. Look at nothing except citizenship. And since it disclosed neither abuse of authority, they don't consider that abuse of authority, nor the existence of evidence not laid before the secretary. And Holmes argued that even if Ju Toy was a Native American, he could not get any relief from the court since the findings of the immigration officials were conclusive and not subject to judicial review. The Supreme Court determined that refusing entry at a port does not deny due process, since due process can be given without judicial trial for citizens applying for admissions. For citizens applying for admission, I don't think they consider citizens applying for admission anymore, so that fixed that. But that's kind of crazy. Not kind of, it's fully crazy. Therefore, Ju Toy could not obtain reprieve from the judicial system and was subject to be deported to China. Whew. Now, luckily, Justice Brewer and Justice Peckham dissented. Justice Day also dissented. These are the justices at the time. Their dissent argued that Ju Toy had been judicially determined to be a free-born American citizen and had been guilty of no crime, since returning to one's native land is not a crime for citizens. Brewer contested that allowing a citizen guilty of no crime to be deported without a trial by jury and without judicial examination strips him of all his rights which are given to a citizen. Amazing. As a result of the decision, as well as legislation passed in the U.S., China launched a dramatic boycott of American goods in protest, a sign that the struggle over China's exclusion had not ended. So 100 years later, look at what we're doing now. We have boycotts of China, of issues with economics. They're banning admissibility situations for F-1 visas. This is all history repeating itself. So with the decision in Ju Toy, the court blurred the distinction between alien and citizen and determined that both are subject to the same bureaucratic discretion and authority. This decision placed alleged citizens on the same level in admission proceedings before the Bureau of Immigration. After the United States v. Ju Toy case, the number of habeas corpus petitions filed by Chinese in the Northern District of California plummeted from 103 cases in 1904 to 32 in 1905 and then 9 in 1906. So it's a dark day where you have no standing. So if you have foreign descent entering the United States, and obviously it's not going to happen on the East Coast, this was a West Coast thing, and then you never know if you're going to come back in, so you have to stay here. And then when you're here, there's all sorts of other places that's not an immigration thing we're not going to talk about here that hold you back. So it's a difficult time being a foreigner in the United States. It's such a big decision to come to the U.S. and make that leap, for a better life for your kids. It's full of hassle. But, there's a promise, there's a hope that life could be better. It is, despite all this stuff, it was the land of the free compared to the crazy stuff you'll be seeing other parts of the world. I mean, this is 1900s. The First World War is going to kick up a decade and a half later, which is going to be horrible for Europeans and also just their colonies from across the world. 50 years later, we're going to have World War II, which we'll see, millions of Japanese being butchered. Millions of Chinese and Koreans being butchered. Japan being leveled to the ground. Germany and that mess, wars all over the place in their colonies. So, despite all this, U.S. was the place to be. I mean, we're going to have the Japanese internment, which we're going to talk about, which is horrible. But it was better being, I guess, interned in the U.S. than having, the bombs find carpet bombing Tokyo or the Nagasaki, Hiroshima bombs that happened. But it's never, a positive to have liberty taken away. And that's the challenge we have as immigration lawyers and just lawyers in general. Our job is to uphold liberty first and foremost. And that's something we should try our best not to ever lose sight of in whatever we're doing, no matter what. We're the protectors of liberty in this country, more than I think than anyone else than police or Congress people. It's really us who have the education and the position in society and the wealth to be able to do that and keep it going. So I implore you and I beg you to do your part, and I'll try to do my best. Until next one, have a good one.